The Senate Committee on Government Affairs will come to order. Madam Secretary, please call roll.
Vice Chair Orenshaw. Here. Senator Goycochea. Senator Daly. Here. Senator Krasner. Chair Flores.
Present. Please let the record reflect all members are present and we have a quorum. Good afternoon and welcome to the hardworking Committee on Government Affairs. I appreciate all of you being here. We are going to do the work session document first, followed by 2 bill presentations, and hopefully that will make your lives easier. I also have a firm commitment from our senator that both bill presentations will be in a total no longer than 10 minutes. So, in order for us to honor that, we need to get going with the work session document. We're going to go down the order that we have them listed in now. First bill, we have Senate Bill 17. Mr. McDonald, please.
Senate Bill 17 revises provisions related to regional transportation commissions. It was sponsored by this committee on behalf of the Regional Transportation Commission of Southern Nevada. This bill authorizes regional transportation commissions to employ or appoint security officers and expands the authorization to grant money to conduct research and develop projects that promote energy, transportation, and transit technologies. In counties with a population over 700,000, the Regional Transportation Commission is authorized, not required, to establish an advisory committee regarding benches, shelters, and transit stops, and makes it permissive to establish and administer the Nevada Yellow Dot program. We did have 2 amendments for this measure. The first was discussed in the hearing. This was brought by the Regional Transportation Commission of Southern Nevada. This proposed deleting Section 1 regarding the employment of security officers. The second amendment came in subsequent to the hearing, also from the RTCSN. And this amendment, they're proposing to amend it to make Section 2 apply to transportation commissions in counties with a population of 100,000 or more. Change may to shall for the purposes of establishing an advisory committee. Revise the membership and meeting requirements for the advisory committee, and specify the duties of the advisory committee. And you can take a look at those 2 amendments right after the bill page. Thank you, Chair.
Thank you, Mr. McDonald. At this time, I'd like to entertain a motion to amend and do pass Senate Bill 17.
Chair, I move amend and do pass with the 2 amendments in the work session document.
Vice Chair Orenshaw has made the motion to amend and do pass Senate Bill 17. Do I have a second? Senator Daly has seconded that. Members, any discussion? Seeing none, all those in favor, please signify by saying aye.
Aye.
Those against say nay. Motion carries unanimously. And Senator Daly, if I could please ask you that you do the floor statement. Senator Daly will do the floor statement. Next bill, Senate Bill 20.
Senate Bill 20 revises provisions relating to the process for filing a vacancy in a Board of County Commission. This bill was sponsored by this committee on behalf of the Nevada Association of Counties and heard on February 22nd. The bill authorizes a Board of County Commissioners to establish by ordinance a process for filling a vacancy on the board. If a Board of County Commissioners has not established such a process by ordinance, the governor must, with certain exceptions, fill the vacancy by appointment with a person who is a member of the same political party as the most recent holder of the vacant office. And we did have an amendment proposed by the Nevada Association of Counties that seeks to amend subsection 2 of section 1 to add parameters for an ordinance that a Board of County Commissioners may create to fill a vacancy on the board. And if you take a look at the amendment, this starts on the next page. So you'll see some of those provisions there seeking to add, such as a vacancy on the commission must be filled in an open meeting by a majority vote of the entire commission within 30 days. The appointee must have the same qualifications required of the elected official, and the appointee must be of the same political party. Thank you, Chair.
Thank you, Mr. McDonald, and thank you to Senator Daly for working on some of those amendments along with other members of the committee. I'd like to entertain a motion to amend and do pass Senate Bill 20. Senator Daly has made the motion to amend and do pass Senate Bill 20. Do I have a second?
Second.
Vice Chair Orenshaw has seconded that motion. Members, any discussion? Senator Krasner, please.
Oh, thank you, Chair. We have an extensive work session document today, so I'm going to vote yes to get it out of committee and reserve my right to change. Thank you.
Thank you, Senator Krasner. Members, any additional discussion? Seeing none, all those in favor, please signify by saying aye. Aye. Those against say nay. Motion carries unanimously. Vice Chair Orenshaw, if I could ask that you please do the floor statement.
Yes, thank you, Chair.
Vice Chair will do the floor statement for Senate Bill 20. Next, we have Senate Bill 21.
Senate Bill 21 revises classifications based on populations, sponsored by this committee on behalf of the Nevada Association of Counties. This bill revises the classifications of populations in certain provisions of the NRS by raising the population threshold of 45,000 to 52,000. We did have one amendment proposed for this measure. This was brought forward by Mary Walker. It proposes to amend the bill to revise subsection 1 and 2 of NRS 387-331 to increase the population threshold from 55 to 100,000. This amendment will allow Lyon County to continue collecting the residential construction tax on behalf of the school district. Thank you, Chair.
Thank you, Mr. McDonald. At this time, I'd like to entertain a motion to amend and do pass Senate Bill 21.
So moved.
Vice Chair has moved to amend and do pass Senate Bill 21. Do we have a second? Senator Krasner has seconded that. Members, any discussion? Senator Daly, please.
Thank you, Mr. Chair, and I'm hoping we can maybe go back before we do some stuff. So, question on the amendment, by what I read in the section that we're changing and the whole sections on the residential tax, changing it to 100,000, I have no problem with. We want Lyon County to continue and be able to do what they've done. My question is, why exclude a consolidated municipality, which is Carson City? And because all of the language is permissive anyway, there's no reason to exclude anybody. If the consolidated municipality like Carson City doesn't want to do it, don't do it. But the school district should be able to be allowed to ask that municipality to do it, and they can just say no if they like. Excluding it, I got a problem. So, anyway, or questions anyway.
Thank you, Mr. Chairman, and members of the committee. For the record, Mary Walker, representing Douglas, Lyon, and Story counties. And thank you, Senator Daly, for the question. The reason why that language is put in there is because we were just trying to stay with where every county is at the current time. At the current time, or actually in the past, that particular part of the law did not apply to Carson City. And so we were just keeping it the same. That's all it is.
So the Carson City could not have done this under the existing language? So
That's correct. Under the existing language, they couldn't have done it because of the population caps that were in there before. So we just kept everybody the same.
And I understand, but they still can just say no.
Sure,
So-
I
But that,
understand.
I'm fine with it then, if that's the explanation. I understand Carson City's the only one that's a consolidated municipality, so I know you can't name them out by name, though.
That's correct, sir. Thank you.
Thank you for joining us. Senator Goycochea,
Yeah,
please.
thank you, Mr. Chair. And so the three counties that would be outside is Clark, Washoe, and Carson City.
For the record, Mary Walker, yes, that's correct.
All right, thank you. Just making clear.
Members, any additional discussion? All those in favor, please signify by saying aye. Aye. Those against say nay. Motion carries unanimously. And if I could please ask Senator Krasner to do the floor statement. Senator Krasner will do the floor statement on Senate Bill 21. Next on the work session document, Senate Bill 22.
Senate Bill 22 revises provisions related to the publication of legal notices. This bill was sponsored by this committee on behalf of NACO and heard on March 1st. The bill authorizes the publication of a legal notice or advertisement on the internet website of a qualified legal and competent newspaper of a general circulation. If published on an internet website, the legal notice or advertisement must be posted continuously and uninterruptedly for not less than the full period of time that the notice is otherwise required to be published in a newspaper. There are two amendments proposed for this measure. The first was brought forward by Mr. Guthrow of NACO, and this amendment would seek to amend subsection 2 of section 1 to strike out the use of alternative instead of incorporating both publication in a newspaper and posting on the website of the newspaper. amend subsection 3B of section 1 to add clarifying language on continuous posting, amend subsection 5A of section 1 to strike or and replace with and amend subsection 2 of section 3 to clarify continuous posting. And we did receive an amendment subsequent to the hearing from a Mr. Morley, who proposes to insert the word additionally in subsection 2 of section 1 to read as, any legal notice or advertisement may be additionally published on the internet website of a newspaper described in subsection 1. Thank you, Chair.
Thank you, Mr. McDonald. At this time, I'd like to entertain a motion to amend and do pass Senate Bill 22. Senator Daley has made the motion to amend and do pass Senate Bill 22. Do I have a second?
Second.
Vice Chair has seconded that. Members, any discussion? Yes, Vice Chair Orenshaw, please.
Thank you, Chair. I just wanted to clarify, the motion is to accept both amendments, including Mr. Morley's amendment?
That was the way I understood the motion by Mr. Daley. However, Senator Daley, if I'm incorrect, please correct me.
That's correct.
That is correct. It's to accept it with both amendments as proposed including the amendment proposed by Mr. Morley.
Great. Thank you, Chair. Thank you, Mr.
Thank
Senator
you.
Daley.
Members, any additional discussion? Seeing none, all those in favor, please signify by saying aye. Those against say nay. Motion carries unanimously. Next is Senate Bill 24. Mr. McDonald, please. And if I can have Senator Goycochea, if you could please do that floor statement. Senator Goycochea will do that floor statement. Next is Senate Bill 24. Mr. McDonald, please.
Senate Bill 24 revises provisions relating to the Office of Small Business Advocacy within the Office of Lieutenant Governor, sponsored by this committee on behalf of Lieutenant Governor and heard on February 15th. This bill removes the prospective expiration date of the Office of Small Business Advocacy on July 1, 2023. We do have an amendment to this measure that would extend the expiration date of the office to July 1st, 2025. This was proposed by the chair, and you can take a look at the mock-up on the next page. Thank you, Chair.
Thank you, Mr. McDonald. At this time, I'd like to entertain a motion to amend and do pass Senate Bill 24.
So moved.
Vice Chair has moved to amend and do pass Senate Bill 24. Do I have a second? Second. Senator Daley has seconded that. Members, any discussion? Seeing none, all those in favor, please signify by saying aye. Those against say nay. Motion carries unanimously. And I will do the floor statement on Senate Bill 24. Next, we have Senate Bill 82.
Senate Bill 82 revises provisions related to public works. This bill was sponsored by Senator Daley and heard on April 3rd. The bill modifies the percentage of labor hours that are required to be worked for certain projects, depending on how many hours the apprentices will be working, and limits the requirement to enter into an apprenticeship agreement to those contractors or subcontractors who are not signatories to a collective bargaining agreement with the sponsoring union. We did have one amendment proposed for this measure by the sponsor, Senator Daley, and this amendment proposes to amend the bill to provide that requirements for employing apprentices are applied on the basis of public works performed during a calendar year instead of on a per public work basis. Require that a contractor or subcontractor shall be responsible to maintain and provide any supporting documentation that demonstrates that the contractor or subcontractor has made a good faith effort to employ one or more apprentices for a certain percentage of the total hours performed on a public work. Require a contractor or subcontractor beginning in 2025 to submit an annual report to the Labor Commissioner in the Office of the Labor Commissioner regarding the employment of apprentices, and create a penalty schedule for violations of certain provisions related to requirements for a contractor or subcontractor to employ one or more apprentices for a certain percentage of the total hours performed on a public work. Thank you, Chair.
Thank you, Mr. McDonald. I'd like to entertain a motion to amend and do pass Senate Bill 82.
So moved.
Vice Chair Orenshaw has made the motion to amend and do pass Senate Bill 82. Do I have a second? Second. Senator Daley has seconded that. Members, any discussion? Senator Krasner, please.
Thank you, Chair. I do have some concerns about the language, but I'm going to vote yes to get it out of committee and reserve my right to change prior to floor. Thank you.
Thank you, Senator Krasner. Any additional comments? Senator Goycochea, please.
Thank you, Mr. Chair, and I'm going to be just the opposite. I'm going to vote no, but reserve my right after I have time to digest this amendment. I didn't like the bill. He's tried to improve it, but I'm going to vote no anyway. Thank you.
Fair enough. Members, any additional discussion? Seeing none, all those in favor, please signify by saying aye. Those against say nay. Motion carries. Please let the record reflect Senator Goycochea was a nay. All others were ayes. And the floor statement will be for Senator Daly. Senator Daly will be doing the floor statement, Senate Bill 82. Mr. McDonald, Senate Bill 83, please.
Senate Bill 83 revises provisions governing the confidentiality of the personal information of certain civilian employees of law enforcement agencies. This bill was sponsored by Senator Daly and heard on April 3rd. The bill adds the personal information of certain civilian employees of law enforcement agencies to the list of persons and entities authorized to request that certain personal information contained in the records of a county assessor, recorder, the Secretary of State, or a county or city clerk remain confidential. And it also adds those persons to the list of those authorized to request that the Department of Motor Vehicle display an alternate address on the person's driver's license. We have no amendments for this bill. Thank you, Chair.
Thank you, Mr. McDonald. I'd like to entertain a motion to do pass Senate Bill 83. Senator Krasner has made the motion to do pass Senate Bill 83. Do we have a second?
Second.
Vice Chair Orenshaw has seconded that. Members, any discussion? Seeing none, all those in favor, please signify by saying aye. Those against say nay. Motion carries unanimously. And Senator Daly, if you could please do the floor statement for Senate Bill 83. Senator Daly will do the floor statement for Senate Bill 83. Next on the work session document, Senate Bill 92. Mr. McDonald, please.
Senate Bill 92 revises provisions related to sidewalk vendors. This was sponsored by Senator Donache and others and heard in this committee on March 1st. This bill creates requirements for the licensing and regulation of street food and merchandise vendors by the governing body of a county whose population is 100,000 or more. And we did receive an amendment from the bill sponsor. You can find that on the next page. Real briefly here, the amendment, in addition to other changes described in the amendment, revises certain definitions to exclude vendors who sell merchandise, limit restrictions on the hours of operation a sidewalk vendor may operate, limit vendors in Section 9 operating in an area within a set distance to certain establishments, adds penalties in Section 10 for failure to comply with certain ordinances, including suspension or revocation, require a local board of health in Sections 10.5 and 24.5 in a county and city whose population is 100,000 or more to adopt regulations regarding sidewalk vendors on before January 1st, 2024, revises the membership of the task force on safe sidewalk vending and expands its duties, authorizes the Secretary of State to establish an advisory board to support the task force, to support the uniformity of regulations across the state. It prohibits sidewalk vendors in Section 25.5 from operating within 1,500 feet of certain locations. It adds severability clause in Section 28.5 regarding enforceability in certain provisions, if certain provisions are held invalid or unenforceable, and it revises the effective date with regard to the new sections proposed in the amendment. Thank you, Chair.
Thank you. And Senator Doñate, if you could please join us. For the sake of clarity and transparency, I think there was a slight difference in the original amendment that was uploaded, and I wanted Senator Doñate to be here just to clarify the difference. You all do have now a copy of that. And Senator Doñate, anything that Mr. McDonald mentioned that may have come out differently after the final amendment, please.
Sure. Thank you so much, Fabian Doñate, for the record. So I want to quickly just allow the senators on this committee to understand the differences of where the bill was presented to what is presented now. So in the bill, I think our intention has always been to shift the burden of how this is handled in residential areas versus to the industry. And so in the amendment that we have to Senate Bill 92, it will, for folks who are licensed or unlicensed in residential areas, they would be treated with civil penalties. And that was to address the issues of criminalization that many of the street food vendors came before this body to talk about. in the bill, we have worked with stakeholders across the state, both with the city and county jurisdictions, law enforcement, and of course the Resorts Association and other business entities to make the bill as clean as we could. The easiest way that I can explain it to you is rather than segmenting where they can operate and where they cannot operate, we're giving in this amendment more jurisdiction back to the cities to review time, place, and manner. I think that was an important aspect that they had requested. And a significant portion of this bill will take an effect this year in October. As you may know, we have incredible opportunities right now with events coming to Las Vegas. F1 will be coming in November, and the Super Bowl will be coming soon. And so there are parts of this bill that, upon the signage and approval from this body and from the governor, where the prohibition of street food vendors will now be in a particular area. So if you look at section 25.5, that is page 6. Once we reach October 15th, that was the time that we decided, immediately there will be a prohibition on, in a county with a population of 100,000 or more, within a certain distance from a resort hotel as defined by NRS, an event facility that has a seating capacity of at least 20,000 or more, a convention facility, and then we included the Las Vegas sign because it was difficult to find where that would. And in general, what we wanted to ensure is that once this prohibition takes place, you will now have the opportunity not to be able to sell as a street food vendor in those areas. In addition to that, what we had decided was essentially we want to make sure that there are appropriate circumstances that we can cover for folks that may not come into compliance. And I think you see the revisions in the task force as to how we can work together to make this more uniform. And so we've worked with the health districts, et cetera, to essentially look at the regulations that we need in place. The bill is not perfect. There are parts of it that we know folks may not like, but in general, we believe that this is a good bill that has worked with all particular stakeholders and to address the needs of the community. And with that, I'm happy to answer any questions.
And members, I wanted to do a quick clarification. The amendment that you have in your work session document is in fact the same exact one. I just wanted to make sure that, I originally thought that we had accidentally uploaded the wrong one, but it is in fact the same one. So it's the amendment you were working with from the very beginning. However, we do need to make a clarification, and our legal will jump in, please.
For the record, this is Heidi Clarkson with the Legislative Council Bureau. Because this is a law of general applicability, we can't refer to a specific street or a specific sign. So if there's a more general way to describe what is attempting to be excluded here, we're going to need to do that, or else that language has to come out.
Thank you so much, Fabian Duñate, for the record. If the committee chooses the NRS that we can point towards this historical marker, that was a discussion that came up for that particular.
Senator Goycochea, please.
Thank you, and I just want to get it on the record, Senator. Now, in counties under 100,000, it will be business as usual. They'll work with their local health department or whatever, and they can impose whatever ordinances they need.
That's correct. Fabian Duñate, for the record. We started off specifically for this bill to draft it towards Washoe County and Clark County because this is where most of the activity is. If we want to look at it at a later time frame as to how we can support the rural communities, then we'll have the aspect for that. The one thing I will say is the Secretary of State, Cisco Aguilar, has mentioned that he wants to create a one-stop shop for if you want to start a small business, you have one place that you can go and it's not difficult. Making sure that if you have different types of licenses, like how can we bring all those together? This is a perfect vehicle to help have that conversation, and hopefully the rural counties, once we, in the near term, could participate as well if they wanted to.
I appreciate that, and we'll see how this works before we jump on. Thank you.
Members, any additional discussions? At this time, I'd like to entertain a motion. Oh, Senator Krasner, please.
Oh, thank you. We just received a lengthy amendment, so I'm going to vote yes to get it out of committee and then reserve my right to change prior to floor. Thank you.
And Senator Krasner, just for the sake of transparency and clarity, I apologize for causing that confusion. But it is in fact the same exact amendment that you previously had in your work session document. I thought it was a different one, and that's why I provided you an additional copy. I'd like to entertain a motion to amend and do pass with the clarification that was made by our legal, that either we're going to amend that language so that it is broadly written to encompass the intent, and/or remove that language so that we are not in conflict with that drafting.
So moved.
Vice Chair has made the motion. Do I have a second? Daly has seconded that motion. Members, any discussion? All those in favor, please signify by saying aye.
Aye.
Those against say nay. Motion carries unanimously. Next on the work session document, we have in the floor statement, Senator Doñate, if you could please do that. And next we'll go to Senate Bill 94.
Senate Bill 94 revises provisions related to tribal liaison officers. This bill was sponsored by this committee on behalf of the Joint Interim Standing Committee on Natural Resources and heard on March 29th. The bill requires each state agency to employ a tribal liaison. The bill also revises the duties and minimum qualifications of the position of tribal liaison, and we have no amendments for this measure. Thank you, Chair.
Thank you. At this time, I'd like to entertain a motion to do pass Senate Bill 94.
So moved.
Do I have a second? Senator Krasner has seconded that. Members, any discussion? Senator Goycochea, please.
Yes, thank you, Mr. Chair. And now, it's every state agency will have one liaison that will function with all 28 tribes, correct? I just want to get that on the record, that clarification.
And we can have our legal clarify that.
Sorry, Heidi.
Just a second.
Got the bill.
For the record, this is Heidi Clarson. Sorry for the delay. So, Senator Goycochea, you're correct. It's not one liaison per tribe. However, it is each state agency. And the state agency, for purposes of this bill, is defined as an agency, bureau, board, commission, department, or division of the Executive Department of State Government. That's in NRS 233A.250. So there are departments that have multiple divisions. So within a department, you may have more than one tribal liaison, because each division within the department, within the state agency, will have to have the tribal liaison position.
And then, just to follow up, I assume this bill has a significant fiscal note and probably go to finance?
Yes, there are fiscal notes attached to this, so I believe it would be pulled into finance on the floor.
All right, thank you. Thank you, Mr. Chair. I can support it, and we'll see what, maybe we get a limit on the number. I could see a bunch of people otherwise. Thank you.
Thank you, Senator. Any additional comments? Seeing none, all those in favor, please signify by saying aye. Aye. Those against say nay. Motion carries unanimously. And if I could please ask Senator Krasner to do the floor statement. Senator Krasner will do the floor statement on Senate Bill 94. Next on the work session document, Senate Bill 105. Mr. McDonald, please.
Senate Bill 105 revises provisions related to the Department of Corrections. This bill was sponsored by this committee on behalf of the Joint Interim Standing Committee on Judiciary. The bill removes the Nevada Department of Corrections from the list of agencies that are exempt from the Nevada Administrative Procedure Act, and provides that regulations currently adopted by the department remain in effect until they are replaced by new regulations in accordance with the act. We do have one amendment proposed for this measure. This was brought forward by Senator Scheibel, and the amendment will change the bill to provide that the Department of Corrections will remain exempt from the requirements of Chapter 233B of NRS, except as provided in NRS 209-221 and 209-2473, and for the administrative regulations pertaining to fiscal policy, visitation, and mail and correspondence. And there is a conceptual amendment on the next page. Thank you, Chair.
And thank you. And before we take a motion, I believe we have a question. Senator Daly, please.
Thank you, Mr. Chair, and I just wanted to make sure that I understood, and I think when our staff read the provisions, so currently it says that they're exempt except as otherwise provided in 209-2221, and if you go to that, it says those regulations are covered and they have to do it. So now it'll just add these other sections. Otherwise, they're still exempt, and they're exempt for contested cases. So we're making progress, but not all the way. If that's the way I understand it, I just wanted to clarify, so 100% in support.
Melanie Scheibel, for the record, yes, that is exactly correct. And since I have a moment of your time, part of the reason was also that the department pointed out to me that some policies probably shouldn't go through a public procedure for safety concerns when it comes to things like, evacuation routes and security protocols within a prison. We actually might not want that to be publicly available to anybody who might access it later.
And I agree with that also, so thank you.
With that, I'd like to entertain a motion to amend and do pass Senate Bill 105. Senator Daley has made the motion to amend and do pass Senate Bill 105. Do I have a second? Vice Chair has seconded that motion. Members, any discussion? Seeing none, all those in favor, please signify by saying aye. Those against say nay. Motion carries unanimously. And if I may ask that our Senator Scheibel do the floor statement. Yes? Senator Scheibel will do the floor statement for Senate Bill 105. Next, we have Senate Bill 143. Mr. McDonald, please.
Senate Bill 143 revises provisions relating to discrimination in housing. This bill was brought by Senator Neal and heard on March 8th. The bill revises various provisions related to discrimination in housing. Specifically, the bill establishes new procedures and requirements with respect to investigations and hearings regarding complaints to the Nevada Equal Rights Commission with the Department of Employment, Training, and Rehabilitation. The bill has a number of provisions that we've outlined here on the bill page. I think we'll go ahead and skip those and go right to the amendment. You can take a look at the conceptual amendment that was submitted by Senator Neal. That's on the next page. And I'll try to briefly walk you through this. The amendment in section 34, subsection 1, line 18, adds some language that it is lawful to check the background of a person. It deletes section 34(1)A and replaces it with a new section that is listed there under bullet 3. Under bullet 4, section 34, it deletes section 34 sub 1B lines 22 through 25. On bullet number 5, it amends section 34 subsection 1C, and you can take a look at the language that she is proposing there. Bullet 6 is amend section 34(2)B, line 42, and it adds some language if the rental or lease is being made available by a housing authority and the housing authority has adopted a policy to use such offenses as a basis for denying the rental or lease of the public housing and has made a list of the offenses publicly available, any offense set forth in 24 CFR subsection 982553 as a permissive prohibition. Bullet number 3 is to amend section 34 and 31 of the bill to add language that does not apply to single-family residences. As defined in this section, a single-family residence is a person who owns 4 or less separate single-family units. And then finally, under bullet 8, section 8, 34 sub B, line 26, to read a single-family house owned by a natural person or any other housing that is owned by a natural person and has 4 or fewer dwellings, units excluding duplexes and fourplexes. And that's all we have on that bill. Thank you, sir.
Thank you. With that, I'd like to entertain a motion to amend and do pass Senate Bill 143.
So moved.
Vice Chair has moved to amend and do pass Senate Bill 143. Do we have a second? Senator Daley has seconded that motion. Members, any discussion? All those in favor, please signify by saying aye. Aye. Those against say nay. Motion carries unanimously, and we'll ask that Senator Neal do the floor statement for Senate Bill 143. Thank you, Senator, for joining us. Next, we'll go to Senate Bill 155. Mr. McDonald, please.
Senate Bill 155 revises provisions related to homeless persons. This was sponsored by Senator Orenshaw and heard in this committee on April 7th. The bill prohibits a local government from enacting and enforcing any ordinance that discriminates against a homeless person by prohibiting a homeless person from engaging in life-sustaining activities in a public space, including without limitation resting in a non-obstructive manner, sheltering from the elements in a non-obstructive manner, eating, sharing, accepting, or giving food in public spaces where food is not prohibited, and with certain exceptions, occupying a motor vehicle. We do have one amendment for this measure that was proposed by Senator Orenshaw, and you can take a look at on the next page. This amendment proposes to replace Section 2 to clarify a person charged with certain misdemeanors associated with homelessness who shows sufficient evidence that they are homeless may be ordered to complete a program of diversion, a specialty court program, or any assistance deemed applicable by the court, sentenced in accordance with NRS 193150 and exempt from the fines, administrative assessments, or fees related to the charge. Finally, the amendment provides a definition of sufficient proof of homelessness, permits but does not require justice courts and municipal courts to create treatment courts for pre-prosecution diversion for individuals who are chronically homeless, and makes a few conforming changes throughout the bill. And you can, again, take a look at that amendment on the next page. Thank you, Chair.
Thank you, Mr. McDonald. I'd like to entertain a motion to amend and do pass Senate Bill 155.
So moved, Chair.
Vice Chair has made the motion to amend and do pass Senate Bill 155. Do I have a second?
Second.
Senator Daly has seconded that. Members, any discussion? Vice Chair Orenshaw, please.
Thank you. Well, I wanted to thank the committee, thank Ms. Barron from the ACLU of Nevada and all the other stakeholders, Judge Walker, Judge Liu, the court administrator, Judge Birchie from Reno, and really trying to work on replacing the language we had in the bill. This is a gut and replace with what I think is a really great diversion program for our unhoused brothers and sisters who find themselves arrested and will probably never be able to pay those fines. And that can just lead to more bench warrants, more contact with the criminal justice system, which isn't going to help them land back on their feet and hopefully find housing, find other services that they need. So I appreciate all the help. There's one thing in the work session, Chair, where I just want to make sure it's clear, because I think, and Senator Daly brought this out to me, where it says replace Section 2, the whole bill's, the original language is going away.
One and two.
So, and it's being replaced with the new language in the amendment, so
One and two.
1 and 2. So, just for clarity's sake, thank you, Chair.
And thank you for clarifying that. And just for the sake of clarity, legal, please.
Just so I can clarify to make sure I understand the intent of the motion to amend and do pass, Senator Orenshaw presented a conceptual amendment at the bill hearing where it listed numerous statutes, and that is still incorporated in this amendment. It's sort of a combination of the conceptual amendment and this additional amendment that was submitted to sort of clarify how the two work together. Is that correct?
That's correct, Chair, and through you to Ms. Clarson. The original language in Section 1 and 2, though, as to the counties and cities, and that language would go away. And that'd be deleted from the original bill via the amendment.
Thank you. So then the amendment would delete the bill in its entirety as introduced and then combine the conceptual amendment that was presented to the committee at the bill hearing that I believe is already on Nellis and this additional amendment. So it's amend and do pass, but with the conceptual amendment from the bill hearing and this amendment and removing the other two sections from the bill as introduced.
That's correct. Through you, Chair, to our legal counsel. Yes, the original language is going away, and then this potential for this diversionary therapeutic court, should local governments decide to implement it, would be available for the unhoused if this passes.
Senator Goycochea, please.
Thank you, Mr. Chair, and I'm going to support the bill out of committee, but I want to reserve my right when I see the bill actually put together. Thank you.
Senator Krasner, please.
Thank you, Chair. I really want to commend the sponsor of the bill. The original bill, I wasn't so sure about, but, he completely gutted the language. He brought in some very well-respected judges, Judge Liu, Judge Walker, and it's now a diversion court. for our homeless people. And I think it's an excellent solution, and so I will be a yes. Thank you.
Thank you, members. Any additional discussion? All those in favor, please signify, all those in favor of Senate Bill 184 with the amendment, with the conceptual amendment that was presented during, 155, with the conceptual amendment that was presented during the bill presentation and the amendment as proposed in our work session document with the clarification that there's a deletion of section 1 and 2. All those in favor, please signify by saying aye. Aye. Those against say nay. Motion carries unanimously, and our vice chair will do the floor statement. Mr. McDonald, Senate Bill 184, please.
Senate Bill 184 revises the charter of the City of North Las Vegas. This was sponsored by Senator Spearman and Flores and others, and heard in this committee on March 27th. The bill makes various changes to the charter of the City of North Las Vegas, including increasing the number of wards in the city from 4 to 6, requiring the city manager and certain appointed administrative officers to reside in the city, requiring the city manager to prepare an annual diversity study and establish a supplier diversity program, providing that the city attorney or any attorney with whom the city council enters into a contract to perform all or a portion of the duties of the city attorney may not opine or provide legal advice to the mayor or council on any issue or matter that does not directly relate to the official duties of the mayor or the council, requiring the city manager to submit reports to certain legislative committees regarding vacant or leased space in the North Las Vegas City Hall, and a report to the Joint Interim Standing Committee on Legislative Operation and Elections during the legislative interim. We did receive one amendment from the bill sponsor. This amendment proposes to amend the bill to delete references in Section 5 related to the residency requirements for city officers. Just to clarify that a little bit, that will not affect the city manager portion of the bill. Thank you.
Thank you, Mr. McDonald. At this time, I'd like to entertain a motion to amend and do pass Senate Bill 184. Or before I do that, Senator Spearman, were you hoping to add something to the record? Please do.
Yes, sir, Mr. Chair. Thank you. Senator Spearman, representing Senate District 1 in Clark County. And I don't know, I had a call from one of the members of the Charter Committee. I don't know if he had a chance to get on, but he said if he didn't, he gave me permission to read into the record his letter. And I think he sent it maybe to all of the committee members. So with your permission, sir, okay. Honorable Senators, my name is Tyrone Jones. As a member of the North Las Vegas Charter Committee, veteran and longtime resident of the City of North Las Vegas, I've been asked by other members of the Charter Committee, the Clergy Alliance of North Las Vegas, veterans, and other citizens of North Las Vegas to support the passage of SB 184 to address this correspondence to your attention. Members of the NLV Charter Committee were contacted by Senator Pat Spearman April 7, 2023, where she informed us that she had been contacted by attorney Christina Kleist, representing the City of North Las Vegas in opposition to SB 184. Senator Spearman informed us that her discussion with Ms. Kleist centered around if and what considerations and concessions could be considered pertaining to SB 184. Subsequently, Senator Spearman referred Ms. Kleist's inquiry and contact information to myself and another member of the Charter Committee, Timothy Smith, Senator Spearman, another member of the Charter Committee. Senator Spearman's position on the matter, and as relayed to myself and Tim Smith, was that any discussion of compromises and/or concessions should be decided upon by the citizens of North Las Vegas. We've made attempts to reach Ms. Kleist to discuss these issues to no avail. We've also made additional attempts to invite key members of the North Las Vegas City Administration to discuss and work out these issues and matters. That's also been to no avail. Thank you for your time, respectfully. So the amendment that you have there is one that I received from several organizations in the City of North Las Vegas to include members of the Charter Committee. I just want to clarify that. And one more thing, Mr. Chair, I think there was a fiscal note on here related to redistricting. I called the Secretary of State's office and asked them to give me some information on what it cost previously. Unfortunately, they don't have inclusive records with respect to North Las Vegas, but they did give me the cost of redistricting for the City of Las Vegas, which is significantly larger than North Las Vegas. And that cost was $40,000, and it was 1231.21. And so that's quite a big difference between 1 million, and if it costs Las Vegas $40,000, I don't imagine that it would cost North Las Vegas $1 million. That's it.
And thank you, Senator. With that, I'd like to entertain a motion to amend and do pass Senate Bill 184.
So moved.
Vice Chair Orenshaw has made the motion to amend and do pass. Senator Daly has seconded that. Members, any discussion? Seeing none, all those in favor, please signify
Chair.
by saying, oh, excuse me, I apologize.
Yeah, thank you.
Senator Goycochea,
I've got to
please.
explain my position. I really appreciate the sponsor and her work on the bill, but I just continue to have reservations about this body mandating that we change some wards without allowing the Charter Committee to actually do their work. And I understand what's down there, and there's some real loose, whether in fact they had the ability to do it or not. I was really hopeful we would get to a point where the Charter Committee could do their job and get it done right and give them some direction. So I have to be a no on this. I'm a home rule guy, and I believe in letting the local people do it, and this is a mandate from us. So sorry, that's where I'm at.
Thank you. Members, any additional discussion? Seeing none, all those in favor, please signify by saying aye. Aye. Those against say nay. Motion carries. Please let the record reflect that Senator Goycochea was a nay. The rest of the members were ayes. Senator Spearman, if I could have you please do the floor statement for Senate Bill 184. And by the way, Senator, I know that you recently got recognized for the National Federation of Democratic Women True Blue Award. Obviously, that's a huge honor, and just wanted to say congratulations. Thank you, Senator. With that, we will now go to Senate Bill 185. Mr. McDonald, please.
Senate Bill 185 revises provisions related to businesses. This bill was sponsored by Senator Neal and heard on March 15th. The bill creates the Business Opportunity Outreach Unit within the Purchasing Division and defines the duties of the unit to include, among other things, establishing a database of minority-owned businesses, women-owned businesses, businesses owned by persons with disabilities, local emerging small business and micro businesses, and establishing annual goals concerning the awarding of contracts to such businesses. Finally, the bill requires local governments and using agencies of the Executive Department to cooperate with and submit information to the Business Opportunity Outreach Unit. And we did have a conceptual amendment that was proposed by the sponsor during the hearing, and you can take a look at that on the next page. And I'll just kind of try to briefly run through these again so that you can recall. It amends Section 3, Sub B3 to remove the words gain and understanding. Adds to Section 3, Sub B3, the words state and local government through the RBDAC, which stands for the Regional Business Development Advisory Council, will create and assist, provide pathways for microbusinesses to bundle to become eligible for a procurement opportunity. Adds to Section 3, the words create, assist, and provide virtual education and pathways to become eligible for bonding insurance in the local and government procurement process. Deletes Section 3, Sub 8, and then add the word coordinate with RBDAC on existing database and emerge information to establish a shared system of data for statewide system. Section 3, subsection 5, it adds a microbusiness has 1 to 9 employees. The definition of the microbusiness is that it makes under $75,000 a year in gross revenue. Section 3, sub C, sub 9, line 11, add they must report total amount of RFPs issued and the total responses per professional potential business and responses from agency political subdivisions on the request for proposal. And you can take a look at the rest yourself there. Thank you, Chair.
Senator Neal.
There was one quick amendment missing to add Senator Krasner to a sponsor on the bill, please. Thank you.
And I think they'll just pass around a little form that you can, So we don't have to do it formally here. Although I will let you know, Senator Neal, that if you make our poor staff read through 10 minutes worth of amendments, we're going to start cutting those bills out of here. With that, I'd like to entertain a motion to amend and do pass Senate Bill 185. Senator Krasner has made the motion to amend and do pass Senate Bill 185. Vice Chair Orenshaw has seconded that. Members, any discussion? Senator Krasner, please.
I wanted to thank Senator Neal for bringing this excellent bill that relates to economic development and creating businesses and business opportunities in our state, and thank you for allowing me to sign on as a co-sponsor.
Members, any additional discussion? All those in favor, please signify by saying aye. Those against say nay. Motion carries unanimously. Senator Neal will do the floor statement for Senate Bill 185. Next, we'll do Senate Bill 225. Mr. McDonald, please.
Senate Bill 225 revises provisions governing peace officers. This was sponsored by Senator Harris and heard on April 5th. The bill requires an application for certification as a peace officer to include an affidavit stating the applicant is not disqualified from serving as a peace officer, has not been discharged, disciplined, or asked to resign from employment with a law enforcement agency for certain misconduct, and has not resigned from the employment or otherwise separated from employment with a local law enforcement agency while an investigation is ongoing. We did have one amendment that was proposed by the sponsor, and you can take a look at that on the next page. It seeks to add the affidavit, to the affidavit a requirement that an applicant attest that they have not been discharged for conduct that would result in the revocation of a certificate of a peace officer under regulations adopted by the commission. Require law enforcement agency to notify the commission of a peace officer resigns from employment while an investigation is pending. Clarifies the attestation regarding the use of cannabis before and after the submission of an application for employment and screening for the use of cannabis as a condition precedent to employment or continued employment. And finally, it revises the effective date. Thank you, Chair.
Thank you, and thank you, Senator Harris, for all the work I know you did working with the law enforcement. With that, I'd like to entertain a motion to amend and do pass Senate Bill 225. Senator Daly has made the motion to amend and do pass Senate Bill 225. Do I have a second? Vice Chair has seconded that motion. Members, any discussion? Seeing none, all those in favor, please signify by saying aye. Those against say nay. Motion carries unanimously. Senator Harris, if you could please do the floor statement. Senator Harris will do the floor statement for Senate Bill 225. Next, Senate Bill 226. Mr. McDonald, please.
Senate Bill 226 revises provisions governing public works. This was sponsored by Senator Canizaro and Assemblyman Yeager and heard on March 29th. This bill makes a declaration of legislative intent regarding the payment of prevailing wages to workers on public works projects that are funded in whole or in part by public money. We did have one amendment for this bill that was proposed by Mr. Saavedra. This amendment, you can take a look, starting on the next page, proposes to amend the bill to revise the declaration in Section 2 to clarify the intent regarding novel leasing and financing arrangements for incentives provided by local governments or governing bodies of local governments for development of construction projects. The amendment deletes Sections 3 and 4. It retains the definition of horizontal construction and vertical construction in subsection 14 and 25 of section 5 respectively. It clarifies that prevailing wages apply on subsection 3 of section 7 on certain types of projects as if the public body had undertaken the project or had awarded the contract. It excludes certain types of construction of affordable housing in subsection 4 of section 7 from prevailing wage provisions. And finally, it defines affordable housing in subsection 5 of section 7. Thank you, Chair.
Thank you. At this time, I'd like to entertain a motion to amend and do pass Senate Bill 226. Senator Daly has made the motion to amend and do pass Senate Bill 226. Vice Chair has seconded that motion. Members, any discussion? Senator Goycochea, please.
Thank you, Mr. Chair, and I appreciate the work. And again, it's like the last amendments we saw. I'm going to vote no and oppose this bill until I can actually walk through the amendment. But my constituency is adamantly opposed because of the connection to both affordable housing and the fact if you ever had a piece of property that if you donated 10 feet of it, it became a public works project, even if it was a nonprofit or an NGO. So I've got to, until I look at the amendment, I'm no.
Thank you. And Senator Krasner, please.
Thank you, Chair. I did have some concerns, so I will vote yes to get it out of committee, but reserve my right to change to a no prior to floor. Thank you.
And thank you, Senator Krasner. Members, any additional discussion? Seeing none, all those in favor, please signify by saying aye.
Aye.
Those against say nay. Motion carries. Please let the record reflect that Senator Goycochea is a nay. All other members are ayes. And the floor statement will be done by Senator Canizaro. Next on the work session document, Senate Bill 246. Mr. McDonald, please.
Senate Bill 246 revises provisions related to governmental administration. This bill was sponsored by Senator Neal and heard on March 22nd. The bill revises the city charters of the City of North Las Vegas and Las Vegas to require each city to establish a workforce development program in coordination with all applicable agencies that provide workforce development services to reduce the rate of unemployment in all areas that have a high rate of poverty. The bill also creates an exception to the provision that authorizes but does not require the City Council of the City of Las Vegas to exercise certain powers and enact ordinances related to programs to employment and training. And finally, the bill makes an appropriation of $5 million from the State General Fund to the Southern Nevada Enterprise Community Board. There are two amendments proposed for this bill, and they were both proposed by Senator Neal. The first was discussed during the hearing, and that is included on the next page. Subsequent to the hearing, we received an amendment from Senator Neal that proposed an amendment to amend subsection 2A of section 3.110 for the City Council to receive an update on the workforce development program established pursuant to subsection 1 on a quarterly basis instead of at every meeting. And that's all I have on this measure. Thank you, Chair.
And thank you, Mr. McDonald. At this time, I'd like to entertain a motion to amend and do pass Senate Bill 246.
So moved.
Vice Chair Orenshaw has made the motion to amend and do pass Senate Bill 246. Do I have a second? Senator Daly has seconded that. Members, any discussion? Seeing none, all those in favor, please signify by saying aye. Those against say nay. Motion carries unanimously. And I will ask that Senator Neal carry the floor statement for Senate Bill 246. Next, Senate Bill 247.
Senate Bill 247 revises provisions related to regional housing, sponsored by this committee and heard on March 22nd. This bill authorizes, instead of requires, the Board of County Commissioners and the City Council of each of the three largest cities in a county whose population is 700,000 or more to establish a regional planning coalition by cooperative agreement. We have no amendments on this measure. Thank you, Chair.
Thank you. I'd like to entertain a motion to do pass Senate Bill 247.
So moved.
Vice Chair has made the motion to do pass Senate Bill 247. Do I have a second? Senator Goycochea has seconded that. Members, any discussion? Seeing none, all those in favor, please signify by saying aye. Aye. Those against say nay. Motion carries unanimously. And if I could please ask Senator Goycochea to do the floor statement. I appreciate that. Senator Goycochea will do the floor statement on Senate Bill 247. Next on the work session document, Senate Bill 262. Mr. McDonald, please.
Senate Bill 262 revises the qualifications for membership on certain advisory councils and boards. This was sponsored by Senator Flores, Doñate, Scheibel, and others, and heard on March 29th. This bill eliminates the requirement that a member of a town advisory board or citizens advisory council be a qualified elector. We have no amendments on this measure. Thank you, Chair.
Thank you, Mr. McDonald. I'd like to entertain a motion to do pass Senate Bill 262.
So moved.
Vice Chair has made the motion to do pass Senate Bill 262. Do I have a second? Senator Daly has seconded that. Members, any discussion? Senator Goycochea, please.
Thank you, Mr. Chair, and I have to oppose this, given my constituency. I just can't put if you're not a qualified elector on the ballot. So with that, I have to oppose.
Senator Krasner, please.
Thank you, Chair. I do have some concerns, so I'll be a yes to get it out of committee, but reserve my right prior to floor to change my vote. Thank you.
And thank you, Senator. Members, any additional discussion? Seeing none, all those in favor, please signify by saying aye. Aye. Those against say nay. Motion carries. Please let the record reflect Senator Goycochea is a nay. All other members are ayes. And I will be doing the floor statement for Senate Bill 262. Next, Senate Bill 271.
Senate Bill 271 revises provisions related to discrimination. This bill was sponsored by Senator Neal. Requires an attorney who works for, contracts with, or provides volunteer services to the Nevada Equal Rights Commission within the Department of Employment Training and Rehabilitation to review any complaint filed by the commission alleging an unlawful discriminatory practice and prepare all findings of fact and final dispositions of complaints. We have no amendments on this bill. Thank you, Chair.
Thank you, Mr. McDonald. At this time, I'd like to entertain a motion to do pass Senate Bill 271.
So moved.
Do I have Vice Chair Orenshaw has made the motion to do pass Senate Bill 271. Do I have a second? Second. Senator Krasner has seconded that motion. Members, any discussion? Seeing none, all those in favor, please signify by saying aye.
Aye.
Those against say nay. Motion carries unanimously, and Senator Neal will do the floor statement for Senate Bill 271. Next is Senate Bill 299.
Senate Bill 299 revises provisions related to monorails. This bill was sponsored by Senator Flores and others and heard on March 31st. The bill requires the payment of prevailing wages on any work, construction, alteration, repair, or other employment performed, undertaken, or carried out by or for any railroad company or any person operating the same, regardless of whether a public body is party to the contract. Similarly, the work of or incident to the installation and operation of a monorail may be subject to the prevailing wage requirements. And finally, the bill provides that a monorail is a public utility. We do have one amendment that was proposed for this measure by Mr. Donahue, and the amendment proposes to delete subsection 2 of section 1 regarding apprentices recorded under the provisions of Chapter 610 of NRS and retain existing language in section 2 to clarify that a monorail is not a public utility. Thank you, Chair.
Senator Daly, please.
Thank you, Mr. Chair, and I think it's just maybe an oversight or someone forgot, but the deletion of the information regarding apprentices would create a problem that basically I think it's an oversight when they proposed it. But if you look at NRS 338020, which is the main provision in prevailing wage, it says that anytime you employ a skilled worker, semi-skilled, mechanic worker, unskilled labor, perform public work, must contain the express terms of the hourly wage rates, and they can't be paid less than the prevailing wage rate that's been determined. So if you remove that exemption, apprentices would no longer be able to be paid at the percentage rate as being apprentice. So they would have to be paid prevailing wage, same as if they were journeyman. So we don't want to remove that section. So I would make the motion to amend and do pass, retaining that, and all the other provisions of the amendment would be fine.
Thank you, Senator Daly. Senator Daly has made the motion to amend and do pass Senate Bill 299 with the clarification that we would accept the amendment that's proposed in the work session document with the exception that the strikeout in purple that reads apprentices recorded under the provisions of Chapter 610 of the NRS would remain in the bill.
So moved.
And Senator Orenshaw has seconded that motion. Members, any discussion? Senator Krasner, please.
Thank you, Chair. I do have some concerns with the language, so I'll vote yes to get it out of committee, but I reserve my right to change to a no vote on the floor. Thank you.
Senator Goycochea, please. Senator Goycochea has diddled Senator Krasner's comments. Thank you. Members, any additional comments? Seeing none. All those in favor, please signify by saying aye. Aye. Those against say nay. Motion carries unanimously, and I will do the floor statement for Senate Bill 299. Next, Senate Bill 301.
Senate Bill 301 revises provisions related governing public works. This was sponsored by Senator Lang, Donate, and Spearman, and others, and heard on March 31st. The bill provides that employed at the site of a public work also includes the delivery or removal of construction material or structures to or from the site of a public work. And we did have one amendment. This was discussed at the hearing where Senator Lang proposed to amend the meaning of employed at the site of a public work to include the delivery or removal of construction materials to or from the site of the public work. to include, and then it limits it here to aggregate, asphalt, and concrete. And that's all we have on this bill. Thank you, Chair.
Thank you, Mr. McDonald. At this time, I'd like to entertain a motion to amend and do pass Senate Bill 301. Senator Orenshaw has made the motion to amend and do pass Senate Bill 301. Do I have a second? Senator Goycochea has seconded that motion. Members, any discussion? Senator Krasner, please.
Thank you, Chair. I want to reserve my right to vote no on the floor, but I will vote yes now to get it out of committee. Thank you.
Thank you, Senator. Members, any additional discussion? Senator Goycochea, please.
Yes, thank you, and I seconded the motion. I really appreciate the work that the sponsor of the bill did and others trying to get to this point. It's a lot better than it was when we started, but I also have to reserve my right when we get to the floor. Thank you.
Thank you, Senator. Members, any additional discussion? Seeing none, all those in favor, please signify by saying aye. Aye. Those against, say nay. Motion carries. Please let the record reflect that Senator Daly is a nay. All other members are ayes. And we will have Senator Lang do the floor statement for Senate Bill 301. Next on the work session document, Senate Bill 305.
Senate Bill 305 provides for the establishment of a retirement savings program for private sector employees. This bill was sponsored by Senator Harris, Spearman, Hansen, Neal, and others, and heard on April 5th. This bill establishes the Nevada Employee Savings Trust under a board of trustees and requires covered employers to automatically enroll all covered employees in the Nevada Employee Savings Trust program unless a covered employee opts out. We did receive an amendment for this measure from Senator Harris, and you can take a look at that on the next page. The amendment proposes to revise the definition of covered employer in Section 8, revise Section 19 to replace the Lieutenant Governor with the State Treasurer as the chair of the board, require in subsection 3 of 21 that each officer, agency, division, or department of the state provide information as necessary for the board to implement the program, revise Section 23 to allow a covered employer to enroll a covered employee in a similar program offered by a trade association or chamber of commerce, require, with certain exceptions, in Section 35 that the board establish the program and implement its provisions so that covered employees are able to make contributions to an individual retirement account through the program beginning on July 1, 2025. The section also further authorizes the board to implement the program in 2 phases if the board decides to do so, but the first phase must not begin before July 2025. And then the amendment also revises the effective date. Thank you, Chair.
Thank you, Mr. McDonald. I'd like to entertain a motion to amend and do pass Senate Bill 305.
So moved.
Senator Orenshaw has made the motion to amend and do pass Senate Bill 305. Do I have a second? Senator Daly has seconded that motion. Members, any discussion? Senator Goycochea, please.
Thank you, Mr. Chair, and I really appreciate the sponsor's work on this bill. I will be voting yes out of committee, but want to reserve my right, and I really thank you for the 5. Appreciate, I would have preferred 25, but okay.
Senator Krasner, please.
Thank you, Chair. I'll vote yes to get it out of committee, but also reserve my right to change prior to floor. Thank you.
And thank you, Senator. With that, any additional comments? All those in favor, please signify by saying aye. Aye. Those against, say nay. Motion carries unanimously. And Senator Harris, if you could please do the floor statement. Senator Harris will do the floor statement on Senate Bill 305. Next, Senate Bill 318.
Senate Bill 318 revises provisions related to homeless persons. This bill was sponsored by Senator Scheibel and Harris and heard on April 5th. The bill authorizes the governing body of an incorporated city to impose an annual surcharge on users of sanitary sewer system in an amount not to exceed $25 multiplied by the equivalent residential unit calculated for the user by the incorporated city. The bill further requires the incorporated city to account for the proceeds of the surcharge and use those proceeds to provide services or affordable housing for persons who are homeless or indigent within the incorporated city. We have no amendments on this measure. Thank you, Chair.
And thank you, Mr. McDonald. I'd like to entertain a motion to do pass Senate Bill 318. Senator Daly has made the motion to do pass Senate Bill 318.
Second.
Senator Orenshaw has seconded that motion. Members, any discussion? Senator Krasner, please.
Thank you, Chair. I do have some concerns with the language, so I am going to vote yes to get it out of committee, but reserve my right to change prior to floor. Thank you.
Thank you. Senator Goycochea, please.
Thank you, Mr. Chair, and I realize I believe it's only enabling. I need to clarify that. It doesn't require it, so if it was required, I would be a no. It's not required, it's enabling. Vote yes, reserve my right. Thank you.
Understood. Thank you. Members, any additional discussion? Seeing none, all those in favor, please signify by saying aye. Those against say nay. Motion carries unanimously. And our very own Senator Shivo will carry the floor statement for Senate Bill 318. Next is Senate Bill 320.
Senate Bill 320 revises provisions related to the legislature. This bill was sponsored by Senator Harris, Stone, and Donate, and Assemblymember Watts, and others, and heard on April 5th. The bill authorizes a member of the Senate or Assembly to elect to participate in the Public Employees Benefit Program as if the member were employed by the Legislative Council Bureau on a permanent and full-time basis. We did have one amendment that was discussed during the hearing. This was proposed by Senator Harris, who, this amendment will clarify that only members elected or appointed on or after November 5th, 2024 may elect to participate on a full-time basis. Thank you, Chair.
And thank you, Mr. McDonald. I'd like to entertain a motion to amend and do pass Senate Bill 320.
So moved.
Senator Orenshaw has made the motion to amend and do pass Senate Bill 320. Do I have a second? Senator Goycochea has seconded that motion. Members, any discussion? Seeing none, all those in favor, please signify by saying aye. Those against say nay. Motion carries unanimously. And Senator Harris, if you could please do the floor statement. Senator Harris will do the floor statement for Senate Bill 320. Next, we have Senate Bill 323.
Senate Bill 323 revises provisions related to peace officers. This bill was sponsored by Senator Severs Gansert and others and heard on April 10th. The bill requires the Peace Officers Standards and Training Commission to adopt regulations to establish standards for the reciprocity of a person from another state or the federal government with a certification or law enforcement training equivalent to serve as a Category 3 peace officer in this state. And we have no amendments on this bill. Thank you, Chair.
Thank you, Mr. McDonald. I'd like to entertain a motion to do pass Senate Bill 323.
So moved.
Senator Orenshaw has made the motion to do pass Senate Bill 323. Do I have a second? Senator Goycochea has seconded that motion. Members, any discussion? Seeing none, all those in favor, please signify by saying aye. Those against say nay. Motion carries unanimously. And Senator Severs Gansert will carry the floor statement. Next on the work session agenda, Senate Bill 371.
Senate Bill 371 revises provisions governing local governments. This bill was sponsored by this committee and heard on April 12th. The bill authorizes a Board of County Commissioners and a governing body of an incorporated city, except as expressly prohibited by statute, to enact any ordinance or measure related to affordable housing, including without limitation rent control. We have no amendments on this bill. Thank you, Chair.
Thank you, Mr. McDonald. I'd like to entertain a motion to do pass Senate Bill 371.
So moved.
Senator Orenshaw has made the motion to do pass Senate Bill 371. Senator Goycochea has seconded that motion. Members, any discussion? Senator Krasner, please.
Thank you, Chair. I do have some concerns with the language, so I will vote yes to get it out of committee, but reserve my right to vote no prior to floor. Thank you.
Thank you, Senator. Senator Goycochea, please.
Thank you, Mr. Chair, and for my jurisdiction, this works. I'd prefer to have the Board of County Commissioners talking about rent control than I would this body, so thank you.
Thank you, Senator. Any additional comments? Seeing none, all those in favor, please signify by saying aye.
Aye.
Those against say nay. Motion carries. Please let the record reflect Senator Daly is a nay. All other members are ayes. And I will do the floor statement for Senate Bill 371. Mr. McDonald, Senate Bill 373, please.
Senate Bill 373 revises provisions related to language access. This bill was sponsored by Senator Flores, Dañate, Nguyen, and Neal, and Assembly members Gonzalez, De Silva, and Torres, and heard in this committee on April 12th. The bill requires the head of each agency of the executive branch to designate the vital information and documents related to the services of the agency and ensure the information and documents are translated and made available in the 12 most common languages spoken in the state. The bill also requires the head of each executive branch agency to submit a report to the governor and the director of the Legislative Council Bureau regarding the identification and dissemination of the information and documents described in the bill. I have no amendments for this bill. Thank you, Chair.
Thank you, Mr. McDonald. Members, as you recall, when I presented Senate Bill 373, at the very end, in neutral testimony, we had folk from the Nevada Commission for Persons Who Are Deaf and Hard of Hearing join us in that conversation. And they wanted for us to consider what I believe is a friendly amendment to include under NRS 232.0081, Section 1, subsection B, lines 11, to read as follows: ensure that all vital information and documents are translated and made available in the 12 most common languages that are used by persons with limited English proficiency in the state, and then add this language: inclusive auditory, visual, manual, and spoken language, as determined by the last preceding national, et cetera, et cetera. Just for the sake of clarity, it was never our intent to leave them out, and I appreciate the fact that they reached out and to provide this amendment. So it is now my motion to amend and do pass with my bill as presented with this additional amendment. If somebody will make the motion to amend and do pass Senate Bill 373.
So moved.
Senator Orenshaw has made the motion to amend and do pass Senate Bill 373. Do I have a second? Senator Goycochea has seconded that motion. Members, any discussion? Seeing none, all those in favor, please signify by saying aye. Those against say nay. Motion carries, and I will do the floor statement for Senate Bill 373. Next on the work session, Senate Bill 384.
Senate Bill 384 establishes certain provisions related to the award of grants of federal money by state and a state agency for the development of broadband services and infrastructure. This bill was sponsored by Senator Daley and heard on April 7th. Senate Bill 384 sets forth a legislative declaration regarding the importance of using a well-trained workforce and providing jobs to residents of this state in expending federal money to increase the development of broadband services and infrastructures in the state. The bill sets certain requirements related to the awards of grants of federal money by state agencies based on certain factors and relative weights. We did receive one amendment for this measure. This was discussed in the hearing and proposed by Senator Daley. This amendment will require an applicant to submit an application certifying that the applicant, broadband service provider, or contractor will meet certain requirements defined in the bill, and clarify that any certification provided by an applicant is binding upon the applicant receiving the grant money or a contractor performing any work financed in whole or in part with the grant money. Thank you, Chair.
And thank you, Mr. McDonald. At this time, I'd like to, actually, let me hold on that. We do want to clarify something for the record. Senator Daley, please.
Thank you, Mr. Chair, and again, in the busyness of getting the amendments right, I must have submitted the wrong one, or at least not the most updated one. So we did pass out a revised one. It's very similar to what it was, but in section 3(1)B, we deleted A in parentheses and or, so it just reads, meets the requirements of paragraph B of subsection 2. And then we added some language on page 2. We added in number 9 under A, 2A. And basically to clarify, because if you remember in the hearing, you have an applicant, if they perform work, they have to meet all the requirements of the labor standards or be signatory to an agreement. If they go with a provider as a sub-grantee, and someplace there has to be a provider, they're covered by the standards to do this. Or B, what this clarifies is if they self-perform the work, either one of those, the applicant or the broadband sub-provider, and they're not a contractor licensed to NRS 624, the prevailing wage requirements would not apply to that portion of the work, only to a contractor. So that's what number 9 clarifies in this correct amendment. Sorry for the confusion.
Thank you. So Senator Daley has made the motion to amend and do pass Senate Bill 384 with the correction and with the amendment that's now on everybody's, before everybody. And if I could please entertain a motion to amend and do pass.
So moved.
Senator Orenshaw has made a motion to amend and do pass Senate Bill 384 with the conceptual amendment that was presented by Senator Daley. Do I have a second? Senator Daley has seconded that motion. Members, any discussion? Senator Goycochea, please.
Thank you, Mr. Chair, and as I look at this bill, I'm going to have to oppose it. You know, we're still a right-to-work state. I believe this requires that you be, you know, a union shop in order to bid any of these. Clearly, we struggle to have enough contractors out there, especially in northern eastern Nevada, without limiting that hard. Thank you.
Thank you. Senator Krasner, please.
Thank you, Chair. I do have some concerns with the language, so I will vote yes to get it out of committee, but reserve my right to vote no prior to floor. Thank you.
Thank you, Mr. Chair, and appreciate the comments of my colleague, but it doesn't require you to be a union contractor to bid on the project. It just requires you to comply with the labor standards and go forward with that. So you don't have to be a union contractor. You do have to meet the standards or be a union contractor in order to get the 30% preference that's in there. So like I said, anybody can bid on the project as it's written.
And thank you. Members, any additional discussion? Seeing none, all those in favor, please signify by saying aye. Aye. Those against say nay. Motion carries. Please let the record reflect Senator Goycochea is a nay. All other members are ayes. The floor statement will be carried by Senator Daley. Next on the work session document, Senate Bill 388. Mr. McDonald, please.
Senate Bill 388 revises provisions related to certain public employees. This bill was sponsored by Senator Scheibel and heard in this committee on April 10th. The bill allows for a provision of a collective bargaining agreement entered into between certain state employee groups and the executive branch to establish a negotiated rate for employee retirement contributions rather than a matching rate, and requires the employer to pay the remainder of contributions required on behalf of the employee. We did receive an amendment for this bill that was submitted by the bill sponsor, Senator Scheibel, and this amendment proposes to delete sections 1, 2, and subsection 5 of section 4, and clarify that the subject of collective bargaining under subsection 2 of section 3 includes the payment of a portion of the employee contribution rate established pursuant to NRS 286-421 by the employer and any corresponding increase in salary for each employee. Thank you, Chair.
At this time, I'd like to entertain a motion to amend and do pass Senate Bill 388. Senator Orenshaw has made the motion to amend and do pass Senate Bill 388. Do I have a second? Senator Daley has seconded that motion. Members, any discussion? Senator Goycochea, please.
Thank you, and I probably really have a question on this as much as anything. I just want to make sure what this bill does. It allows you to collectively bargain for the payment of your PERS contribution. Long and short?
That is exactly correct, Senator Goycochea.
Thank you, ma'am.
Senator Daley, please.
Thank you, Mr. Chair, and I know Mr. McDonald just read the amendment. Just wanted to clarify and make sure we have it right. In the one that I have here says 246.421. He said 286. Is it supposed to be 286?
Melanie Scheibel, for the record, it is supposed to be 286, and I did discuss this with Mr. McDonald earlier. It's a Scrivener's error, so we would ask that if you amend and do pass it today, that error also be corrected with the first reprint.
No worries. You saved me, so I'm not the only one that made errors here, so.
Thank you for that clarification, Senator Daley. Members, any additional discussion? Seeing none, all those in favor, please signify by saying aye. Aye. Those against say nay. Motion carries unanimously, and Senator Scheibel will carry the floor statement for Senate Bill 388. Next, we have Senate Bill 391.
Senate Bill 391 revises provisions related to governmental entities. This bill was sponsored by Senator Harris and Assemblymember Watts and Backus and heard on April 5th. This bill prohibits a county, a city, and an unincorporated town from sounding a siren bell or alarm for a purpose other than alerting persons to an emergency, testing the siren bell or alarm at reasonable time intervals, or celebrating or recognizing a legal holiday. The bill further authorizes the Attorney General to bring a civil action to collect a monetary penalty from a county, city, or an unincorporated town for each violation. Finally, the bill prohibits a county, city, or unincorporated town from taking adverse employment action against employee for reporting such a violation. And we did have one amendment proposed for this measure. It was submitted by Senator Harris, and the amendment seeks to limit the testing of a siren bell or alarm to not more than once every 6 months. Thank you, Chair.
Thank you, Mr. McDonald. I'd like to entertain a motion to amend and do pass Senate Bill 391. Senator Krasner has made the motion to amend and do pass Senate Bill 391. Senator Daly has seconded that motion. Members, any discussion? Senator Goycochea, please.
Thank you, Mr. Chair, and while there's no way I condone the sundown siren, I can't support this bill because we're impacting dozens of communities all across the state. And I equate this to if Carson runs out of water, then we're going to turn around and pass a law that says nobody takes a bath. It's that much overkill in my mind. So I'm very supportive. We need to stop the sundown siren, but you're impacting dozens of communities all over this state. And so I can't support it because of that. Love to work with you, see if we can get something else better, but thank you.
Members, any additional discussion? Seeing none, all those in favor, please signify by saying aye. Those against say nay. Motion carries. Please let the record reflect. We have one nay by Senator Goycochea. All other members are ayes. And we will have Senator Harris carry the floor statement for Senate Bill 391. Next on the work session document, we have Senate Bill 433.
Senate Bill 433 revises provisions relating to prevailing wage. This bill was sponsored by Senator Daly and heard on April 7th. The bill makes a declaration of legislative intent concerning the interpretation of the provisions governing prevailing wages. We did have one amendment proposed for this measure. Senator Daly proposes to amend the bill to do the following. Delete all sections of the bill as drafted except for the following two provisions. They are that the Labor Commissioner is not bound by any determination or finding of a public body related to the applicability of NRS 338013 to 338090 inclusive, and any determination made by the Labor Commissioner regarding those statutes is a final order of the Labor Commissioner for purposes of judicial review. The amendment also adds a new provision directing the Labor Commissioner to adopt regulations regarding factors to be considered when determining the applicability of 33813 to 338090 and changes the effective date to upon passage and approval. Thank you, Chair.
Thank you, Mr. McDonald. I'd like to entertain a motion to amend and do pass Senate Bill 433.
So moved.
Senator Orenshaw has made the motion to amend and do pass Senate Bill 433, and Senator Daly has seconded that motion. Members, any discussion? Senator Goycochea, please.
Probably just pretty much the same argument. A lot of my constituents, and I think you've probably seen the letters in the packet, but are very concerned about how it will impact affordable housing, and we think it's a stretch. I have to oppose it. Thank you.
And Senator Krasner, please.
Thank you, Chair. I do have some concerns with the language, so I will vote no to get it out of committee, but reserve my right. I'm sorry, yes to get it out of committee, but reserve my right to vote no on the floor. Thank you.
And thank you, Senator. Members, any additional comments? Seeing none, all those in favor, please signify by saying aye. Those against say nay. Motion carries. Please let the record reflect that Senator Goycochea is a nay. All other members are ayes. And Senator Daly will be doing the floor statement on Senate Bill 433. Last on the work session document, Senate Bill 434.
Senate Bill 434 revises provisions related to public retirement systems. This bill was sponsored by Senator Neal and heard on April 10th. The bill makes long-term substitute teachers eligible for membership in the Public Employees Retirement System. The bill also replaces the time rule with the frozen benefit rule, whereby the community interest in such retirement benefits is frozen at the salary base and years of service of the party participating in the retirement system on the date on which the decree of legal separation or divorce is entered. We did have one amendment proposed for this measure. Senator Neal proposes to amend the bill to do the following. It authorizes parties upon mutual agreement to request the court to review the division of community property in a final divorce decree and the accuracy of any qualified domestic relation order. Requires an attorney to provide verbal and written notice to clients in divorce proceedings, which the notice must explain the function and legal ramifications of a qualified domestic relation order on the client's pending divorce, and to obtain written acknowledgement of said notice prior to the inclusion of a quadro in a divorce decree drafted by the attorney. The amendment also removes references to homemaker in Section 3 and makes the effective date of the bill upon passage and approval. Thank you, Chair.
Thank you, Mr. McDonald. At this time, I'd like to entertain a motion to amend and do pass Senate Bill 434. Senator Ornshaw has made the motion to amend and do pass Senate Bill 434. Do I have a second? Senator Daly has seconded that motion. Members, any discussion? Senator Goycochea, please.
Just a question for the sponsor there. I think this got me to where I needed to be, but technically, when you talk about this quadro, it will be effective at the point the divorce happened and the division will happen, whether it be PERS, the house, whatever, will happen at that point. You kind of changed it up on me, so I just want to be clear.
Senator Dina Neal for the record. So basically, it will apply to the PERS benefit, and so when they divorce, that is when it will freeze, and whatever is the community property that has been, I guess, attributed to the marriage will then be divided based on that day of divorce.
Thank you. That's what I wanted to hear.
Senator Ornshaw, please.
Thank you, and I appreciate the sponsor's hard work on this bill. I'm supporting it today. I just have a few unanswered questions that I'm going to circle around with you and maybe some folks who understand family law. Reserve my right, but I'm supporting today. Thank you, because I'm not one of those folks for sure.
Senator Krasner, please.
Thank you, Chair. I do have some concerns with the language, so I will support and vote yes out of committee and reserve my right to change prior to floor. Thank you.
And Senator Neal, just to add to the mystery, I too will reserve my vote. Any additional comments? All those in favor, please signify by saying aye. Aye. Those against say nay. Motion carries unanimously with the mystery that all of us are reserving our vote. You don't know what's going to happen. And with that, Senator Neal, if you could please do the floor statement. Thank you. Senator Neal will do the floor statement. We need Senator Spearman in here immediately so that we can move these bills, if that's the intent. If I could. Yes. Before we do the 5-minute break, and we will do a 5-minute break, I just would like to acknowledge, and if you could all give a quick round of applause to Linda, Suzanne Spence, Ms. Heidi Clarkson, and Mr. McDonald for the amazing work that they've done for this committee. Nothing we do works without you, and we are incredibly humbled and lucky to have all of you on our team. I just wanted to say how much we appreciate you all. And hopefully we'll be out of here soon. We're going to do a quick 5-minute break. And hopefully Senator Spearman is here to present her bills. Otherwise, we'll close it out. And then just so everybody has a heads up, we don't intend to meet on Monday. Thank you, everybody, for the incredibly hard work that you've done in the past couple of weeks. And then we'll be meeting on Wednesday and start listening to some of those assembly bills. With that, we are in recess for 5 minutes. Please, just 5 minutes. And Senator Spearman, if somebody is out there listening, I need you to get over here as soon as possible, please. The Senate Committee on Government Affairs will come back to order. Now, welcome back, Senator Spearman, whenever you're ready.
Thank you, Mr. Chair. Let me use this. On my back now. Chair Flores and committee members, for the record, I'm Senator Pat Spearman, representing Senate District 1 in Clark County, and I'm here to present to you today Senate Bill 272, which continues my ongoing work for equity and equality. This is what the bill does. Sections 1 through 4 require each state agency or local government on or before September 1 of each year to post in a conspicuous place on its internet website, 1, the total number of dollar amount contracts awarded by the state agency or local government during the immediate preceding fiscal year, and 2, the total number and dollar amount of contracts awarded by the state agency or local government during the immediately preceding fiscal year to minority-owned businesses, women-owned businesses, and LGBTQ businesses. Finally, Section 5 of the bill provides that the measure is effective on July 1, 2023. This concludes my presentation. Thank you for the opportunity, and I hope that you will support this bill. Thank you, sir.
Senator Spearman honored her 2.5-minute presentation, and we very much appreciate you for that. Members, any questions for Senate Bill 272? Senator Daley, please.
Thank you, Mr. Chair, and thank you, Senator Spearman. I don't think the information is bad. I don't know what we're going to capture with some of it. I understand on the 233 and 232, there's more information going to be gained there. On the 338 side of it, prime contractors is who the agencies deal with. And for instance, we'll use like DOT. Across the state for the prime contractor that DOT deals with, there might be 30, 40 contractors. And they're all the same ones. Most of them are in-state. You're not going to capture much information about those being minority. They're usually larger corporations. There's some. And they have DBE programs. And I don't know how you drill down to get that information, but a lot of it's public. Essentially, you're going to get number of contracts, a dollar amount, and I don't think you're going to, not that they're not trying, not that there isn't minority participation, because there is. But you're not going to capture anything on that. So I didn't know if that was a concern. But it wouldn't be bad to see the number of contracts and the dollar amounts. It should be interesting information.
Yeah, I think, will it be a challenge? But that's why people in high places are paid the high dollars that they are. And one of the things that I think we have to become more committed to, and that is increasing the diversity. Because you have small businesses that are minority-owned, women-owned, veteran-owned, LGBTQ-owned, and if we never make an attempt to make sure that there is some inclusion, it'll never happen. And so it is my hope that we may start, and it may just be big contractors, but somebody in the supply chain will say, oh, the thingamajig broke, and so call somebody to fix the whatchamacallit, and while they're at it, the dooflachi needs fixing too. All of those are probably small business people that could use that money. I know the small business people could have used the money during COVID. And so this is more than just a pipe dream. This is really a challenge to figure out how we can include more diversity in our supply chain. Our state, one of the reasons why at the national level they're talking about changing the way that the presidential elections go is because our state more and more is looking like America. The question is, are we treating the people who look like America equally, or are we doing the same thing the same way all the time? And so what this is, whatever we can capture, and after that first year, let's look at it. Well, you all look at it. I won't be here, but you look at it and see if it can be improved. But I do know that if we never start, it'll never happen.
And I understand. And like I said, the FHWA and most contractors, they have, the provisions where they're going to require DBEs or at least good faith efforts to advertise and reach out to those contractors. And on large building contracts, convention center, medical building at the university, they'll have one prime contractor. That's who's going to be listed on your list. They'll have 114 or 150 subcontractors or other providers on that job, but this isn't going to capture it, and I understand that. And they're required to take the low bid. I don't think there's any barriers to people bidding some of these things. I just was trying to say the expectation on the information you're going to capture, at least on the public works
you know,
part, is pretty narrow.
Thank you. I didn't mean to interrupt you, but we can always amend it to make sure that there are provisions in, the HR person would know what it is. The CFO ought to know what it is. And so we can always amend it to say, you know, if it's a major corporation that's doing the work, then how many people are on that job? You know, we did that a couple of years for PLAs. So I don't think it's impossible. I hear what you're saying, but more and more, we have small businesses that are lingering on the vine because in our own state, they never get a chance to bid on the contracts. If we never start, it'll never happen.
Members, any additional questions? Senator Goycochea, please.
Yes, thank you, Mr. Chair, and I'm just trying to get my arms around this. Okay, they're going to, local government will go through any performance contract or whatever they issued in the previous year, do it by September 1. I guess a couple of things. Are we going to have a check the box or when they apply, or how do we know whether they are in fact minority woman-owned? How are we going to track that?
Senator Spearman, Senate District 1, Clark County. So the way that they would track that is the way they track information right now. And most of the time, a DBE will be identified as such. And if they can't figure that out, we can amend this to say, ask the question. But most DBEs will be identified as such. Here's what, Senator Goycochea, here's what I'm trying to get at. I don't think that the small businesses, especially the minority businesses, and let me go straight to the veteran-owned businesses, are woefully short when it comes to getting government contracts. Wrap your head around that. Some of these veterans have been to combat, protecting our right to do exactly what we do right here. And we're not dodging bullets or bombs falling on us. And they come back home and they open up a small business, but nobody thinks, or very few people think, to even reach out and ask them for a contract. The other thing that people could do, and this is something that I suggested to our city manager throughout COVID, and that is work with the Urban Chamber, the Latino Chamber, the Women's Chamber, the Veterans Chamber. If companies are really genuinely intent on diversity, equity, and inclusion, don't put the alphabets on the wall. Go and reach out to those chambers, because they'll have members that will fit the bill and will be able to do it. And I can't remember which session it was, but one of the sessions we even said that it's if you can't post the bond, you can always work under someone else. And so that's really what this is for. It's to say we are the most diverse, one of the most diverse states in the country, and we ought to be letting some of our community members who have businesses make sure that they are sharing in the pie.
I hear exactly what you're saying. I'm just trying to figure out how they're going to track it in the local government and whether they're going to, in fact, do they know who they bid when they bid it? Predominantly, they'll go to low bidder.
Yeah.
And
Well,
then you
that's
won't
okay.
know.
Like I said, I can amend the bill and put that in there, and, it shouldn't cost any more, because most everybody's using electronic forms right now. So
And maybe
unless they got a
maybe
high.
it's just to check the box
Yeah.
that you are a minority.
Yeah,
Maybe
that's
you
it.
are a
That's
LGBTQ.
good. That's
All
good.
right.
That's a good suggestion.
Thank you.
Members, any additional questions? Seeing none, Senator, if I could invite you to sit back, and I'll invite those wishing to testify in support of Senate Bill 272, either in Las Vegas or Carson City, to come forward. Seeing no one coming forward, BPS, can we please go to the phone? Support for Senate Bill 272.
If you would like to testify in support of Senate Bill 272, please press *9 now to take your place in the queue. The public line is open and working. There are no callers at this time.
Thank you. Next, we'll go to those wishing to testify in opposition to Senate Bill 272, Carson City or Las Vegas. We have, oh, I'm sorry, Are you in support in Las Vegas or in opposition?
I'm almost a supporter, but there's just a part of it that I was going to make a suggestion
In
to
opposition?
change.
No, no worries. So we'll go to opposition for
Opposition.
Senate Bill 272. Please state your name for the record.
My name is Susan Prophet. I'm the Vice President of Nevada Republican Club. And I got to say, I am impressed with you, Senator Flores. You have the ability to move through 34 bills like a trained auctioneer. That was impressive. And I liked a lot of this bill. So I'm sorry to have to say I can't support it. But I have a professional background that may explain why. I'm an executive recruiter, and I've placed an awful lot of minorities over the years. But I would say more frequently in the last 15 years. The first part of my career, yes, there was a lot more discrimination. But I really think that whenever people are forced to hire, making their hiring decisions based on identity, it shortchanges the department you put them in and the candidate and the people that they're working with, because you can't always guarantee that you're building the team that's going to thrive together. And so a lot of things are considered when you're choosing a candidate, and their abilities and experience are not the only factors. In order for a department to be successful, you need teamwork, and that brings in personalities, likes, dislikes, that affect a person's ability to function within a group. And if you force them to make decisions based on that, and a small talent pool, which we have now, you're raising the stakes on a bad hire. And the results are going to be mediocre at best if you have to settle to hire a specific minority. And so I really shy away from ever doing that. I mean, things like a child that's a junior in high school would have more of an impact than the person's sexual preference to me, because asking them to move before they go into their senior year would hurt the family, hurt the child. I mean, there's a lot of variables involved. And if we're trying to build a successful infrastructure here in Nevada, I really think we need to be able to hire the best talent for the job and make sure that they fit the existing team. That's the key, because otherwise you're just going to put people in there that are going to disrupt each other. And of course, you can lay the groundwork for adding more minorities in there by the company culture that you develop as the hiring manager. So that's key. All right. So if you want, I'm available. You've got my phone number. I have lots of suggestions on how to hire the right people and how to build teams and companies. So we need to start from scratch in a lot of our areas like medicine and our schools. We really need to go back and start from the ground up. And we shouldn't restrain our ability to hire the best talent, especially now, when there isn't much out there that wants to go to work. Thank you very much. Hope you have a nice weekend. And thanks for the work.
And you too. I hope you have a wonderful weekend. And thank you for that. Anybody else wishing to testify in opposition to Senate Bill 272? Seeing none, we will go to the phones. BPS, anybody wishing to testify in opposition over the phone?
If you would like to testify in opposition to SB 272, please press star 9 now to take your place in the queue.
This is Casey Rogers for the record. I have to oppose this bill, and it has a lot to do with the diversity, equity, and inclusion. I think that our state needs to start going away from that. It's a $3.4 billion industry that is actually starting to prove harmful more than anything. You need to look into that. People are less likely to interact with other people who are of different color, of different race, of different culture, all sorts of things, because they're too afraid to offend somebody just by simple communication and social interaction. And so with that being said, I think as far as it's concerned, you hire on merit, you hire on a bunch of other things, and it doesn't have to be put into such a small box, in my opinion. And that is all I will say on that. Thank you.
And thank you. Anyone else wishing to join us in opposition to Senate Bill 272?
There are no callers choosing to testify at this time.
Thank you. We'll say on the phone, anybody wishing to testify in the neutral position.
If you would like to testify neutral to SB 272, please press star 9 now to take your place in the queue. Public line is open and working. There are no callers at this time.
Thank you. Seeing no neutral in Las Vegas or Carson City, Senator Spearman, any closing remarks?
Thank you, Mr. Chair, and I probably should have been a little bit more articulate when I was talking about diversity. I'm not talking about hiring people specifically for their ethnicity, their gender. I'm saying hire the best person, but don't let that be an impediment. If I applied for a job and people looked at me and I got the job, they might wonder, am I a diversity hire? And I could tell them no. I have a bachelor's, a master's, and a PhD. And I have a master's from the military. And so I happen to be a woman, I happen to be black, but I'm not a diversity hire. So qualifications, yes, but do not let those things that are outside, external, don't let that stop it. And so that's all I have to say, Mr. Chair.
Thank you, Senator. And with that, I'd like to close out the hearing on Senate Bill 272. And I'd like to entertain a motion to do pass Senate Bill 272.
So moved.
Senator Ornshaw has made the motion to do pass Senate Bill 272. Senator Krasner has seconded that motion. Members, any discussion? Seeing none, all those in favor, please signify by saying aye.
Aye.
Those against say nay. Motion carries unanimously, and Senator Spearman will do the floor statement for Senate Bill 272. Now I'd like to open up the hearing on Senate Bill 363.
Thank you, sir. And let the record reflect that Patricia Spearman, Senator Patricia Spearman from Senate District 1, keeps her word. This is what Senate Bill 363 does. It authorizes the Housing Division of the Department of Business and Industry to give priority for affordable housing projects that have preference for women who are veterans, women who are previously incarcerated, survivors of domestic violence, and elderly women who do not have stable or adequate living conditions. It enables the Nevada Housing Division to provide a preference in the account for affordable housing. The trust fund currently does not have such preferences. Currently, in the Qualified Allocation Plan, there are nonprofit, geographic, and USDA rural development set-asides. This will also allow them to take advantage of that. Additionally, since 2019, there's been a veteran preference allowed in the bond program per the IRS. This is what the bill does. There's more information in the bill. It's only about 2 pages, but that's what the bill does, and I would encourage your support. Thank you.
And again, Senator Spearman, we really appreciate the brevity. Members, questions? All right. Senator, if I could invite you to sit back, and I will invite anybody wishing to testify in support of Senate Bill 363, either in Carson City or Las Vegas. Seeing none in Las Vegas, we'll start here. Please.
Paul Catha, CATHA, representing the Culinary Workers Union Local 226. I'll follow the senator's lead. We support this bill. Thank you.
And thank you for joining us. Please.
Good afternoon. Sarah Adler, representing herself. I could actually go on a long time about this, but I will try not to. I came here 43 years ago to help found Advocates to End Domestic Violence here in Carson City. Lucky me, there was this cute young attorney on the legal committee, and now we've been married almost 40 years. But the thing that struck me so much and continues to, as I've continued to work in domestic violence, is that Victims are economic hostages. And it is the cost of housing and the access to housing that makes them stay with their children in abusive environments. So that's a group that strongly needs assistance. Previously incarcerated women the same way. Their access to housing is very difficult. I want to make two other points: that this bill is permissive, so priority may be given. And then in affordable housing, those projects that end up using affordable housing trust funds, they are only being built by willing actors. It takes a lot more money than what you get out of the trust fund to actually make an affordable housing project work. So I think that you can have confidence that this priority, if it is used, will go to quality and sustainable projects. So thank you very much for the opportunity.
And thank you for joining us.
Good afternoon, Chair
Good afternoon.
Flores and members of the committee. Just for the record, Mindy Elliott, representing the Nevada Housing Coalition. And Senator Spearman reached out to us today, and we've provided some statistics. And fortunately, she didn't bore you with all of our data that we have. I did want to just clarify, the trust fund has between $6 to $10 million a year. We are building millions and millions of dollars, and this bill only provides really gap funding in that trust fund, and it does provide the Housing Division the opportunity to provide a preference to those listed, I'm so tired, but those listed entities that are in 363. I think Senator Spearman has done a really good job of explaining, but I did want to provide a little additional context to you as it relates to the Affordable Housing Trust Fund.
And thank you for joining us. I don't think we have any questions for you. Anybody else wishing to testify in support of Senate Bill 363? Seeing none, BPS, we'll go to the phone. Support for Senate Bill 363.
If you would like to testify in support of SB 363, please press star 9 now. Take your place in the queue.
Hello, committee. This is Elise Monroy Marsala with Bell's Case Government Affairs. I'm calling in today on behalf of the Nevada Coalition to End Sexual and Domestic Violence. And I cannot say anything better than what Sarah Adler said. So I would like to ditto her trailblazing remarks. Thanks, Sarah.
And thank you for joining us. Next caller in support of Senate Bill 363.
If no callers choosing to testify at this time.
We'll stay on the phone. Those wishing to testify in opposition to Senate Bill 363.
If you would like to testify in opposition to SB 363, please press star 9 now to take your place in the queue. There are no callers choosing to testify at this time.
Thank you. Anybody wishing to testify in opposition here in Carson City or Las Vegas? Seeing none, BPS, is there anybody wishing to join us on the phone in the neutral position?
If you would like to testify in neutral for SB 363, please press star 9 now to take your place in the queue. There are no callers choosing to testify at this time.
Thank you. And anybody in Carson City or Las Vegas, neutral position? Seeing none. Senator, any closing remarks you may have?
Thank you, Chair Flores, and I will apologize. I did have some stats that I was supposed to read, and I just kind of rushed over them, so I will give them to you so that they are part of the record. Nevada has the most severe severe shortage of affordable housing in the country. Seniors represent 30% of our extremely low-income renters. 38% of all domestic violence victims will become homeless at some point in their lives. Once a victim survivor becomes unhoused, the risk for experiencing power-based violence significantly increases. In FY 2022, supportive services for veterans' families programs assisted more than 71,300 veterans nationwide. Of those, 10,000 or 14% were women veterans. Per Housing Assistance Council, Nevada has over 270,000 veterans. Of those, nearly 7.6% live in poverty. Over 40,000 Nevada veterans are experiencing housing problems. I encourage you to support this bill. There is a problem that we are facing, and I always say if you don't face it, you can't fix it. So we're facing it, let's fix it. Thank you, sir.
And thank you, Senator. With that, we'll close out the hearing on Senate Bill 363. Members, at this time, I'd like to entertain a motion to do pass Senate Bill 363.
So moved.
Senator Orenshaw has made the motion to do pass Senate Bill 363. Do I have a second? Senator Goycochea has seconded that motion. Members, any discussion? Seeing none, all those in favor, please signify by saying aye. All those against say nay. Motion carries unanimously. And Senator Spearman, if you could please do the floor statement. Senator Spearman will do the floor statement for Senate Bill 363. Congratulations, and thank you for staying with us late. We have a motion, okay. Yeah. Yeah, this is a. We're going to go in recess for a quick minute, just so that we can clarify the rule. We are in recess. The Senate Committee on Government Affairs will come back to order. Senator Krasner, please.
Just that I was hoping for a motion to reconsider, Chair, but of course it's up to you.
And Senator, just know that we know that you reserved your right, and we understand that your constituency may have concerns, and you'll be able to vote no on the floor after having doing that. But I'm concerned because it's my bill of reopening it, and all of a sudden I hurt the bill that I've been working on. So with that, we won't entertain that motion for now, but we will go to public comment. Anybody wishing to join us for public comment? Seeing none, we'll go to the phone. Is there anybody else wishing to join us over the phone for public comment?
If you would like to provide public comment, please press star 9 now to take your place in the queue. The public line is open and working. There are no callers at this time.
Thank you. Thank you, everybody, for the incredibly hard work. I've already said it, but I'll repeat it. Thank you to our amazing staff. Members, appreciate you staying late and all the amount of work you put into this committee thus far. We're going to do this dance again now with the assembly bills. But again, I do appreciate all the work, and I think a lot of you provided a lot of amazing amendments and made a lot of the legislation trying to come through this committee a lot better. So I just appreciate the work and everything you've done thus far. With that, we are adjourned, and we will reconvene next Wednesday.